The first one, UK to Germany, and there the Data Protection Directive 95 helps us. It has a provision on applicable law, and it looks at the question whether you're processing data in the context of the activity of an establishment in Germany. And obviously, if you don't do that, then you can operate under UK data protection law. So that helps e-commerce companies, for example, to work or to offer their products and services into Germany without having to apply German data protection law. The Article 4 then also says if you have an establishment in Germany and you're processing data in the context of the activities of that establishment, German law applies. So we had the European Court of Justice to look at the question what this kind of processing in the context of an activity of an establishment is. I will come to these decisions, but first of all, just the general concept seems to be quite easy. So if you are an e-commerce company in the UK, you have nobody, no establishment, nobody, no sales agent, no nothing in Germany, you're just offering your products, then you can still rely on UK data protection law. The moment you have got an establishment in Germany in the context of these activities, you will have to apply German law. If you look at the same thing from the US, then you are looking at it from a country that is outside the European Union. And again, Article 4 provides us with a relatively simple answer. The only difference is that in addition to the possibility that you have an establishment in Germany, the German law would already also apply if you use equipment in Germany, which is something that is more easily done than one would think, I suppose. It doesn't necessarily have to be equipment owned by the US company, and we know about all the discussions in the group Article 29, whether, for example, using cookies would be use of equipment in the relevant country because you're basically using the computer of the user as a storage place for your cookies. I don't believe that it is triggered that easy, but the many internet companies, especially with respect to Germany, have servers or equipment in Frankfurt to be well connected to the internet, because that's apart from Amsterdam, the most important internet hub in Europe. And with these kind of equipment, which might be installed by the IT company and never be asked the legal department what they think about it, you might easily get into the application of German data protection law if you're basically offering services from the US to Germany. So that is all normal, but now we come to something that is not normal, and that's the surprise. Unlike the UK, when the European Union decides on a directive, we look at it and we think how to implement it, and not just implement it. We correct it. It's a very important step in the process, actually. If you are bothered about that European directives don't work, ask your legislator why they didn't correct it when they implemented it. Just a decision to say it's applicable is in many cases not the right way to do it. But what we also do, and we had cases about that, is that we don't really implement them properly. So in the case of because we think it's just not how we want it, yeah? That is, you don't have to leave the European Union to be you just don't follow it. Yeah? And so that's why we stay, because it's fine. So the Article 13 of the ePrivacy Directive has a provision on unsolicited marketing, and we thought in Germany that's not really privacy law, is it? It's about kind of bothering people. So it's more about the question whether it's more about unfair trade activities or advertising activities. So we basically implemented it in our unfair competition law and not in the privacy law.